Okay, good afternoon, everyone. Welcome back to Business Law 2. Today we're going to be looking at Chapter 45, which involves corporate powers and management. The overall learning objectives, it's a fairly compressed chapter. We're looking at the powers of a corporation to act. We're going to be looking at the rights of shareholders in more detail, and then the duties, powers, and liability of officers and directors. So that's the overall focus for this chapter. In terms of the shared power structure that exists in corporations, obviously shareholders are owners of the corporation. They really don't have a lot of decision-making authority when you think of your day in and day out, operations. The directors are considered the managers of the corporation. Their main responsibility is to act on behalf of the shareholders. So shareholders, if you trust the directors, they will hopefully reflect the best interest of what you have in mind as an owner of the corporation. Officers within a corporation control the day in and day out decisions of the company, as well as interacting with employees. So they make the hiring decisions, the firing decisions, that kind of stuff. That's not necessarily something that shareholders would be concerned with, or even directors. When we talk about broad categories of powers, there are express powers and then there are implied powers. So express powers, these are granted by law and the articles of incorporation. So, whether it be to purchase, use, sell assets, create contracts, issue notes and bonds, invest funds, and so on. Implied could be powers that are beyond express. And so it's usually any power necessary to carry out or execute the mission of the corporation. So when you think of hiring employees, doing marketing or sales plans, anything that really is more the day-to-day activities, those would come under that bundle of implied types of power. Ultra vires, this is a rare situation where a corporation could act beyond the scope of their authority. The rules associated with corporations have really evolved greatly over the 20th century. So if you look to maybe the early part of the 20th century, so the early 1900s, corporations were fairly restricted in the type of business they were allowed to engage in. As we kind of went through the 20th century, we really kind of expanded the powers and abilities of corporations to act in different ways, not just maybe what they initially had entered into as this business entity form. And so ultra vires doesn't really happen that often nowadays because we've given such a broad kind of mandate to corporations. So they really have to do something clearly in violation of what their mandate is. So maybe there are, for example, nonprofit corporations. If all of a sudden they started to become a for-profit corporation, that would be an example of like an ultra vires issue. But in the world of just traditional for-profit corporations, there aren't a lot of restrictions left for them. They're allowed to kind of expand operations, enter into new markets or new types of business. They have really a very rich and great flexibility in terms of what they're allowed to do from an operational perspective. So shareholder rights in more detail, obviously voting. You can either do this, on an individual level, or you can allow through a proxy others to vote on your behalf. You can even do like voting agreements where you agree with other similarly situated shareholders or shareholders that you agree with. You all will say, okay, well, we're going to vote the same way on this particular issue if it arises. You do have what are called potentially preemptive rights. So if they exist, it basically allows shareholders to maintain their voting percentages when corporations issue new rounds of shares of stock. So that would be a preemptive right. You have the right to inspect the books. In theory, the traditional kind of thing was if you own one share of stock, you can show up at corporate headquarters and say, I want to inspect the books. But you do have the right to kind of be to be present and to actually examine what's happening with the financial affairs of your company because you are an owner as a shareholder. You can also do what's called, when we're talking about voting for board of directors, because that's one of the key things that shareholders will do is they'll vote for directors to represent them, so that they'll work with the officers of the corporation to carry out, hopefully, successful business operations. You can do what's called cumulative voting for the board of directors. So, let's say there's 10 board of directors, and, usually you have to vote on, each seat, so to speak, who's going to get a particular seat. You may not have enough shares to influence the impact on every particular seat, but through cumulative voting, maybe you'll say, look, I'm going to put all my votes, instead of voting for 10 directors, I'm going to vote all of my 10, votes, or, based on the number of shares you have, I'm going to put it all into one director seat. And so that what that does is that hopefully assures that your one person will have at least one seat on the board of directors, so that your voice or your concerns can be kind of represented and reflected. Otherwise, if you didn't have cumulative voting, then it's like, well, you would just be voting on one director seat at a time, and odds are you would be kind of voted, you'd be outvoted, unless everyone agreed with you in terms of your choice or selection. Derivative actions, this is another shareholder right. Shareholders can file lawsuits to compel directors who refuse to act in the best interest of the corporation. They must have been a shareholder at the time the alleged act occurred. That's really the only restriction on shareholder derivative actions. The duties, powers of directors and officers. So obviously directors and officers, they are fiduciaries, so they have that special relationship with the company. They have responsibilities pertaining to protecting shareholder investments. They can select and remove officers. They can delegate operating authority to managers, and then they supervise the corporation as a whole. There aren't really many qualifications. You don't have to be a resident of the state where it's incorporated. You don't have to be a shareholder unless that's specified in the Articles of Incorporation. Historically they weren't paid, but compensation is sometimes provided nowadays as just kind of like a modern practice. So, these are just some bundle of rights and powers that directors have in terms of how they interact with officers of a corporation. So just a quick review. We've talked about fiduciary duties. So, that's that duty of loyalty, duty of care that we've mentioned. So I won't read all of that, but just be familiar with, and understand that there is that fiduciary obligation that flows with directors and officers. There's also this idea of what's called the business judgment rule. And, by default, the law presumes that directors and officers are going to exercise decision-making that's in the best interest of the corporation. 2020 is hindsight, as they say. And so, not every, decision that's made, that is executed, results in a profitable kind of like, decision. And so you can certainly go back and critique and say, well, you shouldn't have done this or you shouldn't have done that, as a strategic kind of decision if you're the director or officers. But what we're looking at with the business judgment rule, it acts as a shield for those directors and officers, so that, with the information they had at the time when they made that decision, did they make it in the best interest in terms of their good faith judgment for the corporation? And, as long as, you can establish that, if you were, let's say doing some sort of like shareholder derivative action, you have a huge hurdle to kind of overcome from an evidentiary perspective. Otherwise, by default, we're going to presume that they did act in the best interest of the corporation. So you really have to have some strong evidence to demonstrate otherwise. Liability of directors and officers. There's something called constituency statutes. So prior to the 1980s, directors were not legally allowed to put other groups of interest, employees, customers, suppliers, ahead of the interest of shareholders. Since the 1980s, a lot of states now permit directors to take into account the interests of these other groups. These are called constituency statutes. And, this usually comes up if they're trying to defend against a hostile merger or a takeover, some sort of acquisition. Also, another thing that has kind of come up in recent years is this idea of corporate social responsibility. That's kind of like a modern kind of view of corporate conduct, is to maybe self-regulate as well as fulfill its legal, ethical, and social obligations. You know, and you know, I think there's just the prevailing kind of view that, you know, corporations really do need to do more than just make profits. They need to be able to be socially conscious in how they're able to carry out whatever their mission is. I give the example of Nike with their child labor issues and you know, the problems they've had in the past. You know, just because a country allows children to work doesn't necessarily mean that, you know, a corporation should go and kind of, you know, reap the benefit from that. You know, there's ethics and moral issues associated with you know, having children you know, work in this environment. And you know, that really is that's an example of what CSR is concerned about. There's also this theory called the triple bottom line theory, and this is a subset within the world of corporate social responsibility, and that's where you try and focus in on profits, people, and the planet. And again, you know, it just seems like we're kind of slowly ticking towards a kind of like a cultural corporate climate that, you know, we want to make money, but we also don't want to necessarily, you know, trash the planet or hurt people in the process. And so, you know, you know, it seeks ways in which to try and you know, kind of, you know, have that delicate balance where you can be profitable, but you can also not harm the planet, and you can benefit and uplift the lives of people that are associated with your company. So anyway, hopefully this offers some more insight into the world of directors and officers and shareholders in terms of the rights and the powers and the responsibilities that they have. As you have questions, as always, please feel free to message me anytime. Have a good, safe, and productive rest of the week, and I'll be chatting with you all online. Thank you so much.